just want to thank Judge Michel one more time for his wonderful overview of the territory we're going to cover today. And now it's time to explore some of those areas he touched on a little bit more deeply. And for our first panel, we have an Emory alum, Professor Margot Bagley, is going to be the moderator. We are fortunate enough to have her on loan from the University of Virginia for the semester to come back and teach some classes this semester. So I will turn it over to her.
Great. Thanks, Brooks. Well, Judge Michel is a very hard act to follow, and his incredibly timely and sobering remarks were wonderful. But I think we have the perfect panel here to do just that and to discuss our topic on the role of institutions in fostering and disseminating technological innovation. I'm going to begin by giving highlights of the bios of each of our speakers. Then they will each speak for 20 minutes, and then I'll open the floor the remaining time for Q&A. Our first speaker is going to be Professor Joshua Sarnoff, who is an associate professor of law at DePaul University, where he teaches patent law and other related courses. Prior to joining DePaul, he was on the faculty at American University, Washington College of Law, and also taught at the University of Arizona College of Law. He's a member of the Board of Governors of the Federal Circuit Bar Association and a member of the Board of Directors of many nonprofit organizations. He's written numerous articles and chapters on patent law and other issues, and Professor Sarnoff is what we consider a scholar activist. He's submitted numerous briefs and testimony on important cases and legislation in the Supreme Court and the Court of Appeals for the Federal Circuit and before Congress. He's been a pro bono mediator for the Federal Circuit, a consultant to the United Nations Conference on Trade and Development on International Intellectual Property, Trade, and Environmental Issues, and he received his BS from MIT and his JD from Stanford. Professor Sarnoff will start us off by talking about the choices government can make in fostering and disseminating technology, with a particular focus on climate change technologies as an example. Our second speaker will be Professor Lisa Vertinsky, who is an assistant professor here at Emory, and teaches courses in contracts, intellectual property licensing, and IP. She came to Emory from the law firm of Wolf, Greenfield & Sachs, where she worked on IP transactions, particularly focusing on IP licensing. Prior to that, she worked with another firm, Hill & Barlow, in the areas of corporate and IP law. Professor Vertinsky is affiliated with Emory's Vulnerability Project, where she explores the connection between innovation and vulnerability and the roles that IP does and or can play in addressing or impeding access to health and economic development. She has JD and PhD degrees from Harvard. Her PhD is in economics, and an MA from the University of British Columbia. Professor Vertinsky will be discussing the role of universities in national innovation strategies and how this role should be changed in response to changes in modern innovation processes. Our third speaker will be Professor Michael Carrier, who's from Rutgers University, Camden, and teaches and writes in the areas of antitrust, intellectual property, and property law. He's the author also of numerous books, book chapter and journal articles, and his most recent book, Innovation for the 21st Century, Harnessing the Power of Intellectual Property and Antitrust Law, was published in 2009 by Oxford University Press and released in paperback in 2011. His scholarship has also been influential, being cited by the United States Supreme Court and others. Professor Carrier has law degrees from both Yale University and Michigan Law School. He practiced law before entering the academy with Covington and Burling as a litigator, and also clerked on the Court of Appeals for the Fourth Circuit. Professor Carrier will be discussing ways to promote innovation through copyright law, actions the government can take to promote innovation, and the role of companies and disruptive innovation. Our final speaker will be Professor F. Scott Keefe, who is a professor at the George Washington University Law School and a senior fellow at Stanford University's Hoover Institution, where he directs the project on commercializing innovation and works on the law, economics, business, and politics of innovation. He serves on Hoover's Property Rights Task Force and is a faculty member of the Munich Intellectual Property Law Center at the Max Planck Institute in Germany. Prior to joining GW, Professor Keefe was a professor at Washington University School of Law in St. Louis with a secondary appointment in the School of Medicine's Department of Neurological Surgery. His list of accomplishments is too long for me to go into here. I will just direct you to his bio on the website. He practiced law for several years with Penny and Edmonds before entering the academy, and also clerked, as was mentioned, on the Federal Circuit for Judge Giles Rich. He was recognized in 2008 as one of the nation's top 50 under 45 by IP Law and Business. He is going to close out our formal presentation by exploring some innovations in institutions which have played out well and some that have played out badly, and highlight some features that are common within each type and may be expected to be good predictors of a possible innovation's success or failure. So, without further ado, Professor Sarnoff.
Thank you, Margot. It's truly a pleasure to follow Chief Judge Michel because in addition to his obvious insight, his expressions are always incredibly gracious. So in terms of thanks, I can just say what he said. Let me just add a few things. I'm also delighted to thank the Thrower family for donating a distant relation to be one of my colleagues at DePaul, Susan Thrower. I'm delighted to be here with some good friends. I'm also amused that I'll be sitting to the far right of Scott, at least from my perspective. And I'm also very pleased to be able to be greeted so graciously by the students, the law review, and the school. So all of that is by the way of thanks. In terms of the topic, what he said, it's just incredibly important. I just want to add two things before focusing on my contribution. The first is that Judge Michel is absolutely right about the need for massive amounts of investment. I will raise the less gracious word, progressive taxation and wealth taxation may be a way out of this problem. And even if we're going to rely on market solutions with tax credit effects, that's got to be paid for somehow. The second thing that Judge Michel focused on was the need for assessment. And here, I think we are in deep trouble for many of the reasons that he said. But at the same time, I'm optimistic that my good friend Scott will tell us how to do it right. So with that, let's begin. If I can get this right. So quickly, I'm going to talk about some ex ante or ex post actions, focusing on the government, looking with examples principally drawn from the climate change regime, about which I've recently written, particularly in regard to the patent system. And note that the choices that the government has in terms of how it promotes innovation will have different intellectual property effects, different trade effects, different perceived fairness effects, all of which matter dramatically to what choices we make and how well we do. I've tried to classify these choices in a variety of ways. They're very fluid. Many of, as you'll hear, the subtopics could be put into or will be duplicated in various other categories, so this is not any formal classification. We don't have good data on the benefits and costs of the different approaches. We don't have natural experiments that are particularly meaningful. I'll come back to that point in a minute. Let me start with why it matters, as if I needed to do so after Chief Judge Michel's presentation. First, it matters as trade policy. If we're going to get the jobs back, we have to be exporting more and not importing so much. And intellectual property has been the area where we have been tremendous net exporters, but that's not the only thing that we can export, and the consequences, particularly if one thinks about climate change, of our ability to generate new technologies for mitigation and adaptation, our ability to deploy them around the world, provides tremendous trade opportunities for the country to regain its competitive advantage. Second, it's social policy. We are going to have severe climate impacts. This has been the warmest winter I can remember in Washington and in Chicago, two places I spent a lot of time in. We are going to face all sorts of measures that affect people, and our ability to respond to them effectively will largely depend on technology. Similarly, it is substantial economic policy because not only under UN treaties that we've signed are we going to be obligated to pay for certain measures, but we are also going to be obligated to do so in our own country to make these changes. And the lower the cost through technology pathways we can get there, the better off we are. In addition, if you look at the numbers in terms of electrical power generation, electrical distribution grids, we're going to be spending massive amounts of money. It's better if we do that through better technologies. So this is all about economic policy, getting our infrastructure right, as well as reducing the costs of our obligations when not only do we have to pay for our own mitigation costs, but we also are going to be obligated under our treaty regime to provide what is effectively foreign aid. One could argue it's our historic responsibility and now legal liability to pay for technology transfer to other countries as well. This matters an awful lot. So, how is the government going to decide how it's going to develop the technologies that everybody knows are needed? Well, there are many different possibilities. The first possibility is government procurement. It's been a traditional approach in certain sectors of our economy, particularly the military, software development, at the state level, electric supply. I mean, there are lots of different ways that the government procures stuff, which I'll call a push mechanism, because the government's putting money into the area by inducing a stimulus for the technology to develop. There are different things about the push mechanism that I'll come back to. There are also pull mechanisms where the government can promise not just contract for the technology, but can promise certain kinds of risk reductions to the private market and to private investors. These can include advanced commitments to assure that there's going to be sufficient market demand, many other measures for, loan guarantees, lots of different measures for pulling more money into the market through the private sector. There are, of course, for procurement, trade concerns over market discrimination, non-neutral risk reductions. Lots of these things have to be thought through in a way that doesn't create trade retaliation, trade wars. But the difficult problem in making these decisions, again, I'll come back to these issues, is that we really don't know what the comparative innovation stimulus is of using contracting, government procurement to develop the markets, to prove technology, to fund the research paths of contracting versus direct government development, I'll talk about next, versus subsidies of various kinds to markets. These are the studies that need to be done. This is the kind of assessment that needs to be done, and we're not very good at it. Partly the reason we're not very good at it is we make choices and then we have no way to evaluate what the alternative choice would have looked like. If someone can solve that problem, please see me. Not only will we write a patent for it and be rich, but also the country will really thank you. And we will find a way to publicize it. The second is there are different kinds, as I say, of pull mechanisms. And if one thinks about the government coming in after the fact, or even in advance of the private sector moving in, what will influence the private sector best to move into the markets are going to depend on the kinds of contracts that are negotiated after the fact for the technology purchases. Who gets what kinds of rights? Does the government control the technology in various ways? What kind of IP ownership is going to occur? So these are all issues that need to be sorted through, and I think that you're going to hear much more about this from some of my colleagues, particularly in the context of the university sector, but also in other sectors. Let's move on to the next option, which is direct government production of innovation. The government can do the research and development in-house. This is an example of, I'm focused on DOE's national laboratories. Interestingly enough, some of them are actually managed by private entities, so the relationship between what's public and private is quite confusing. There are other sorts. The CDC obviously is close by, so we can think about how research gets done by having government institutions actually do the research. Interestingly enough, Secretary Chu focused on that. I took the challenge of being Secretary of Energy in part for the chance to ensure that DOE labs and our country's universities will generate the ideas that will help us address our challenges. DOE must strive to be the old Bell Labs in energy research. Interestingly enough, Bell Labs, I think, was mostly private, but this could be done at the federal level. There's been a lot of money spent in the National Renewable Energy Laboratory, again, it's managed by a private entity. And again, there are no necessary IP consequences that flow from making the choice to have the government do the research and development versus relying on the private sector. The NREL has a large portfolio of patents. What they do with those patents, again, depends on the kinds of institutional structures and arrangements that we choose. The problem, again, raises all sorts of difficult questions. What is the scale of money that is available? Things like the Human Genome Project took lots of money. At the same time, private capital might have been mobilized for that. We have questions about who is best situated to fund the kinds of research that we want. We have questions about comparative expertise in identifying and directing scientific research and development, comparative abilities to keep and retain and develop expertise, comparative abilities to develop commercial applications, and comparative abilities to commercialize, market, and license technologies. I suspect you'll hear a lot more about 4 and 5 again in the universities context. We have other forms of government development that's, again, government-directed research in the form of intergovernmental collaborations. This is going to, I think, be increasingly common, and it's going to raise very interesting questions about, again, intellectual property ownership, funding, and all the rest. So I've given 2 examples, particularly the China Memorandum and the U.S.-India Agreement. There's now a U.S.-China Clean Energy Center, which contemplates royalty-free access to IP that comes out of the center. Again, that's a default choice that could make a big difference to how things develop and how technology develops and gets diffused without really very much analysis of, is this the right choice or is this the wrong choice? Secretary Chu, again, said these joint efforts will allow several nations to share the costs and benefits of intellectual property they jointly fund, helping avoid disputes over intellectual property rights, speeding the world's transition to a clean energy economy. Sharing of IPR should be done when the sharing is mutually beneficial, for example, by an exchange of non-proprietary information, another topic I'll get to. Royalty or royalty-free bearing cross-licensing patent pools, open source software distribution, and may very well inure to the commercial benefit of supplying entity by opening up new markets. So we then have, again, one other form of development is government-constructed commons. These are typically already the case in regard to public sector information, particularly in Europe. Direct funded government agency action generates a lot of information that then becomes made freely available without intellectual property restrictions. People who gain access to it may be required to do various things to assure that their uses don't generate intellectual property rights that restricts others from use. So there are many ways to construct commonses. There's a terrific article by Kathy Strandberg, Brett Frischman, and Mike Madison about constructed commons that I refer everyone to. The polar commons in data is one development of intergovernmental organizations pooling their data. Again, Judge Michel referred to the intellectual capital and the need to develop and deploy it. That happens through interpersonal exchanges. There's actual technology commonses. The history is in the biotech area suggests that it's likely to be expanded in other areas. The big question is whether the UN technology mechanism created through the Copenhagen, Cancun, and Durban meetings is actually going to try to construct a commons with intellectual property in some way, and whether governments will play a role in assuring that intellectual property gets put into that commons in some way. Those are going to be very interesting developments to watch. Then we have domestic subsidies of various sorts. If one thinks of universities as the recipients of government research dollars, it's a very important area. There are many studies of it. Scott had a wonderful debate with Artie Rye about how this has either been an incredibly good thing for commercialization and for normative developments or not. I don't want to repeat any of that. Just to note that, again, these are questions that require thought because we don't have good counterfactuals. Even in that case, even assuming Scott is right, the comparison was to the prior regime, not to alternative regimes that could have been made. R&D production, direct market subsidies. Again, we have public R&D funding, co-financing. R&D tax credits, I think the really big ticket item people don't focus on. We have the question of shifting so that, if you change the subsidies for natural gas and other extractive industries, you may end up with something that looks much more favorable to alternative technologies. So what the government does with not only direct R&D tax credits, but other subsidies may make a huge difference to how the market and how technologies develop. The example of the German feed-in tariffs, when you take the tariffs away, the fear is that socially useful technologies might go away because the market conditions don't look right. All sorts of what I'll call administrative subsidies, fast-track patent processing. There's now a humanity prize for what people do with their issued patents. Foreign aid, the amount and costs of foreign aid. If one thinks of technology transfer as a subsidy, the subsidy can go either to the private sector or the public sector in foreign countries. Then there are all sorts of encouragements and threats. Again, these categories are not mutually exclusive. Public sector leveraging of private sector funding is a huge one. The Department of Energy clearly made the decision to rely on this type of effort. Feed-in tariffs, again, loan guarantees, public-private partnerships. Again, access to medicine is a good example for that. Lots of programs to rely on public market behaviors through government encouragement and recognition efforts, government-initiated IP pools, the threats that led to volunteering of the Wright brothers and Curtiss patents to the Manufacturers Aircraft Association pool. Again, these are all things government can do. We don't have any good analysis of what really makes effective regulation. Then there's the much more drastic ex-post measures that the government can engage in, gets much of business particularly nervous for the uncertainty risks that it poses. Direct price control is obviously probably the one that people feel most strongly about, but antitrust enforcement, something that Mike may mention since it's an area of his focus, can lead to all sorts of concerns, but they can also control both the rewards for innovation and assure better diffusion of technology at lower price. Conversely, antitrust flexibility can assure greater collaboration in various ways. So these are, again, government policies, whether it's going to rely on the market, if it is going to rely on the market, how is it going to structure and regulate the market? And again, there's always things like statutory and compulsory licenses. Curiously, we seem to be just not at all concerned about statutory ex-ante compulsory licenses in the copyright field, but just feel very, very antipathetic toward them in the patent area. So in conclusion, we lack comparative empirical evidence in studies. There are relatively few natural experiments across countries. Even if they are there, we don't know whether the cultural factors make a big difference. Again, I've given the example of Bayh-Dole not exploring alternatives. When we do have these alternatives, they would always require evaluation in counterfactual worlds, which haven't existed and don't exist. We also don't know what the normative changes that would result from these different approaches are. And a lot of it, therefore, goes back to, again, assumptions that drive our choices, and there we start fighting the Cold War rhetoric of it's government evil versus market evil. What I've tried to make transparent is the government is going to be involved in this at any number of levels. And we need to think first, going back to Judge Michel, about getting more money into the system, however we do it, whether it's through R&D tax credits that have to be paid for some other way, or through direct government purchasing, direct government production, government subsidies that are directed, whatever. And then we've got the difficult task of trying to figure out what is the best way to invest that money, and I'll leave it to Scott to answer that one.
I'm delighted to be here today and to get to join in this conversation about the intersection of innovation and the law. And I think that, just let me know if I'm too loud or too quiet, but I think that this really is going to set the tone and tie in with a lot of the discussions we're going to be having in the second and the third panel, because we're all struggling with trying to keep up with the way that technology is changing and that innovation processes are changing or could change. And we're also struggling with the changing relationships between the public and the private. And so I'm going to focus for my talk on the role of the university in this process, and in particular on the role of the university, or in a sense the role the university could play in supporting technological innovation for the public good. And note that I'm not using the word commercialization. I view commercialization as part of that broader goal, and the broader goal really is looking at how to get discoveries, opportunities into public use, and that could take many different forms, of which the patent and license path is only one small part, or one big part, depending on your perspective. So I'm going to really sort of give my talk in a sense at a broad level through a series of images, because I want to paint for you a different picture of what the university role could look like. And so I'm going to start with a picture of where we are, where we've come from in terms of the university role in national innovation strategy, and in particularly its role in technology transfer practices. And then I want to give you a picture of where I think we could and perhaps should be going. So universities, as has already been discussed, and as I'm sure you know, occupy a central position in U.S. innovation policy. And you've probably all heard this, or the phrase, in fact, Judge Michel used it, this notion of universities as the engines of innovation. So the idea, right, is that federal and state policymakers channel billions of dollars into universities for the purpose of generating and disseminating knowledge. Right? The notion is this is a public good. We don't want it to be underproduced. And then the notion is that the private sector will come, select from these riches of ideas, and create products and services that will help us to maintain our economic advantage. What's interesting is that we live in a world now where we talk about the knowledge economy, and universities are central knowledge actors. But as the knowledge economy continues to expand in our thought process, governments are now looking to universities for direct economic outputs, right? Our outputs are now, knowledge is now becoming a commodity, and this is just one sort of reflection of the intersection of the public and the private that really is the theme driving my change vision for the university. So again, but we want to start, so we have this notion of universities as engines of innovation. They're fueling the innovation process by contributing these new ideas. This policy view dates back to a very sort of famous and influential blueprint that emerged in 1945, developed by Vannevar Bush for President Roosevelt, called Science, the Endless Frontier. And what this blueprint did was provide a foundation that has endured until now for a comprehensive federal policy on the role of science and its relationship to economic growth. And universities were given a very central place in this picture of innovation strategy. And this blueprint has led to an enduring institutional landscape, right? The notion is we have, and indeed it laid the foundation for the creation of public funding agencies such as the NSF, the NIH, and the Department of, and the DOA, Department of Energy, supporting basic research at universities and other research institutions. This funding supports that basic research up until a certain point, and then the idea is that the private sector will step in and pick up and move these ideas through successive stages of increasingly applied development and commercialization. Another central part of this institutional landscape is the U.S. Research University. The idea is that the U.S. Research University is going to be the home for conducting these independent basic science inquiries that are going to fuel the development of products and services. And underlying this blueprint, this vision for innovation, is really sort of a basic linear model of innovation. And this linear model of innovation asserts, and this is something put forth by Vannevar Bush that's been incredibly enduring, that the funding of basic research is both necessary and sufficient to promote innovation. And the notion is that we can separate out these sort of basic spheres of research from the more commercial spheres of research and development. Now, this linear model of innovation has been widely criticized, right? We all know that there are feedbacks from technology back into science. We all know that there are universities have commercial partnerships. It's been widely criticized. But the basic intellectual landscape and the way in which the university is expected to function in the technology development and transfer process has not changed. And so the blueprint has been remarkably enduring, even as we know that it is not working or performing as it should. And this endurance of the approach has something to do with the fact that we hardwired this linear model of innovation into the law, in particular with the Bayh-Dole Act, which was passed in the 1980s. And the Bayh-Dole Act was widely celebrated at the time of its passage as a novel way of increasing the number of good ideas that enter the market. And at its most basic level, all that the Act did, I mean, it did a huge amount, but what it did was simply shift the presumption of ownership of federally funded inventions and the patents that would be obtained from there, from the government to universities and other research institutions, with the notion that these universities and other institutions could then find private market players to move them down the commercialization path. But underlying that basic change was a decision to incorporate what really is the only major piece of university tech transfer legislation within the patent statute. And so there's an assumption, right? It embeds an assumption that a patent-centric linear model of innovation is going to produce the hoped-for gains, right? And this has been an enduring model that many are talking about as something that needs to change, even while we continue to celebrate the success of the model, and indeed many other countries are at this moment trying to adopt a similar approach. So why are we questioning this model and the underlying Bayh-Dole Act? Well, many promising university inventions, and this is not news to you, remain either unutilized or underutilized. And as a result, we get a lot of costly technology transfer failures. And I categorize these into two different buckets. We've already talked a little bit about the first one, right? This notion of too little private involvement in funding. So we get great ideas, they're supported by public funding. When the public funding runs out, there are many barriers to securing the kind of private resources, not just money, but also private expertise and labs and resource space that are needed to carry the inventions forward. But there's a second kind of technology transfer failure that also occurs, and that's when there's too much private control. So we have certain discoveries, for instance, certain discoveries having to do with stem cell technology or gene technology that have a dual role, both as direct commercial commodities, they can lead to diagnostics, they can lead to new drugs, but also as inputs in critical cumulative future innovation. And if we take those out too quickly, we create too many proprietary rights and restrict access too quickly around these discoveries, we get too little use of these discoveries. So I want this to sort of this notion of technology transfer, that they're really two different categories, both of which are becoming increasingly important. And their technology transfer failures, both the cost of them and the incidence of them, are increasing. And this is leading some to scrutinize our current system of university technology transfer and its underlying legal framework. Now, many of the proposals are actually suggesting that we marginalize the role of the university. So I'm suggesting actually something different. That rather than marginalize the role of the universities, put governments, some argue, government agencies, or alternatively the market, others argue, in greater control of the discoveries at earlier stages, remove the barriers the universities are perceived to create. I argue that we actually want to expand the role of universities to harness the capabilities that they have for managing the dual nature of technology as both public and private. So let me explain a little more what problem I see we're trying to solve and why universities might be good at doing this. So what we have, right, is an increasing blurring of the line between fundamental knowledge and commercial knowledge. We have discoveries that have this dual nature, both as inputs into critical future research and as commercial commodities in themselves. We have development processes that require specialization, that require collaboration. If you talk now to many of the larger companies, particularly in the life science, but also in others, their models now are to export some of their research and development efforts into universities, or to try and engage universities in coming downstream, moving technology and scientific discoveries downstream. That is the sort of the new model. So we've got this dual nature of science, and this dual nature of discoveries, and the dual nature of the discovery process, and we're trying to fit it into a framework that presumed we would be able to separate out these spheres of non-commercial activity funded by the government on the one hand, and private activity that private actors would be incentivized to develop on the other. So this misfit is leading to increasing technology transfer failures. It's certainly not the only cause, but it's certainly a contributing cause. So I argue we need to change the model. And how do we do that? Well, rather than thinking about universities as engines of innovation, we need to also think about what capacities they have to act as drivers. And I'm not saying they have these capacities now, I'm saying they have capabilities that, if properly harnessed, could make them very good managers of the post-discovery development of inventions. They are good sites, or could be good sites given their characteristics, for managing these tensions between the public and the private in different spheres of activity. Now, why is that? What makes them, first of all, what makes them unique, and then why is that, why are those characteristics important in supporting their role as managers? Well, I argue really that there's three basic characteristics that all major research universities share, even though they may vary in many other ways, including differences between public and private universities. But they all share what I call sort of three basic characteristics. One is they're constructed as knowledge commons with public functions. And we've already heard a little bit about commons. The notion, right, simply the notion of a commons is you have a shared resource, and members determine the rules for contributing and using that resource. And these commons are not necessarily open. The notion of a commons is the members determine the openness or closedness of the system, the access to, and who gets access to the resources that they generate. The interesting thing about universities is that's the model in which they're constructed. They have varying types of knowledge commons. It's being referred to in some of the literature as nested commons. And those commons can have varying degrees of openness or closedness depending on the needs of the project. Secondly, universities have multiple stakeholders invested in different aspects of knowledge and use. And you're an example, right, this community here today is an example of a good deal of differing opinions on how knowledge should be used. We have students, we have practitioners, we have people in the academic field. All of you contribute to the conversation on how university resources should be used. And finally, the universities have an autonomous, decentralized governance structure that enables experimentation in the design of these different knowledge commons. It also enables risk-taking. So if we take these unique characteristics of universities, we say, well, okay, so they have these unique characteristics, I'll go with you there. Why is that going to make them good managers? Well, how could we harness those capabilities? Well, in a sense, what these characteristics enable universities to do is to construct varying local commons that can accommodate the kinds of tensions that are arising in pushing discoveries further down the development stream and managing this dual nature of inventions, paying attention both to the problems of ensuring access, but also to the problems of trying to reduce problems of uncertainty, asymmetric information, and other barriers to private involvement at early stages of development. So I argue, and I'm happy to discuss this more at lunch, I would love feedback from many of you who have insights to add. But the notion is that these capabilities can be harnessed to make universities better managers than firms or governments at this post-discovery development. Now, I'm not saying that they can do that without some help, some change from the legal structure. So, for example, one of the changes that I propose is universities need more discretion in selecting innovation paths. The Bayh-Dole Act, for example, has a public mandate focused around patents as a path to innovation, and they also require universities to elect title to patent the discoveries if they want to elect title to them. So there are various aspects of the Act that have to change to allow universities to have more discretion in what paths to follow. Now, along with this discretion has to come responsibility and accountability. We have to be able to measure and account for the decisions that are made by universities. And we have to be able to reward effective modes of getting discoveries into public utilization. And as Judge Michel referenced earlier, one of the critical features of this is finding the right metrics to measure what success means in developing technologies and how to reward that. And so finally, I agree we need more incentives to support organizational innovation in technology development and transfer practices. So I just want to leave you with sort of a couple of questions that I have been thinking about that have sort of informed this notion of expanding the role of universities. What if we treated organizational innovation with as much seriousness as we treat technological innovation? What if we took the mandate of maximizing the public benefit from use of university inventions more seriously? What if universities competed to maximize social impact of technology instead of focusing on rankings, which are largely a product of where your federal grant dollars come from, for example? And what if these organizational innovations were properly identified, measured, and rewarded? Where could we go? So I'm not saying that universities as they are today should be put in this manager role, but I am saying that they have capabilities as organizations which we have to exploit in a better way, and this will involve pushing them into activities further down the development stream and in managing those activities. And so maybe instead of thinking of them as knowledge commons, I'll end with this, maybe we could instead thinking of them as innovation commons and start focusing on the parameters around those and how the law can support and reward effective participation of universities in those roles. Thanks for your time.
Well, first, I want to thank the students and Brooks for all their hard work in putting together this symposium. You never notice the students and everyone behind the scene until they mess up. And the fact that we haven't noticed any of that just shows how flawless and smooth everything has been. I know how much work it's been, so I'm really grateful for all of your work. I'm also grateful for this symposium on innovation. I've been thinking about innovation for a while. I talk as an academic. I spend a lot of time by myself and with my family, so I talk about innovation a lot, and I'm looked at like I'm from outer space. I have a couple girls who learn the art of eye rolling from a very young age, and so I get a lot of eye rolls, and so it's really exciting to be at a place like this symposium today, where not only do I get to talk about it, hopefully without the eye rolls, but also to hear other people talking about innovation. So it really is a lot of fun. So what I'm going to talk about are a couple things. First, what the government can do for innovation, building on a lot of the comments this morning. And second, something that has not come up, which is the relationship between copyright and innovation. So in terms of the government, let me just start off with 3 facts. The first is that kids today between the ages of 8 and 18 spend 7.5 hours a day on the computer, watching TV, or playing video games. Second, 49% of American adults do not know how long it takes for the Earth to revolve around the sun. And third, the U.S. government spends less on energy R&D than U.S. consumers spend each year buying potato chips. So if you think of how much money is spent, really there could be a lot more that could be done. And so the first thing is, what can the government do? And Judge Michel's point this morning was exactly right, that we live in hard times. But what we're talking about in the grand scheme of the budget is not something that is going to bust the budget. And these things certainly can be done. And in the last couple of budgets, the Obama administration has recognized that more money should be able to go to innovation. So the first thing is basic research. As Lisa talked about, basic research is really crucial. It is research where we don't know the ultimate application to which the ideas will be put. And so we can't completely rely on private industry to fund basic research because they're not going to be able to reap the rewards of everything they do. And so we need the government to do this. The government pays for 57% of all basic research, and unfortunately the cost or the funding of basic research has decreased significantly in recent years. And so it was a high of about 3% of GDP in the 1950s and 1960s, thanks largely to the space program. And since that time, other than a blip in the 80s in which it rose to 2.5% of GDP thanks to the defense budget, since that time it has been reduced. And so now it's 1.5% or 2% of the budget. The basic research is only 0.3%. And so the Obama administration has said we need to do more. Let's set a goal of 3% of the budget. There was $18 billion of proposed spending in 2012, and this is of vital significance. Again, we need to rely on the government for this basic research funding, because even though private industry does so much and so well in terms of application and development, they're not going to do everything we need for basic research, so funding is one place where the government can do something. Second is science and engineering. The United States is not doing as well in science and engineering as it used to do. You look at 1/3 of fourth graders not being proficient, or less than 1/3 of fourth graders being proficient in science, less than 1/5 of eighth graders being proficient in science. You look at 15-year-olds across the world, and the United States ranks 28th in terms of math, 24th in terms of science. You look at middle school teachers and see that half of them don't even have a math degree, the ones that are teaching math, about the same for science. And so really more needs to be done in terms of what's known as STEM, science, technology, engineering, and math, to do more to help today's students. And there have been some proposals. There was one just a couple days ago in terms of funding more teachers, giving them more opportunities, coming up with the hope of 100,000 new teachers in the next 10 years, and giving them skills by which they would be able to bring these math and science skills into the classroom. All of this, again, relies on funding. It's not like we're talking about the entire federal budget here. It's a small piece, and if you at least make the point that it's a small down payment to pay on the price to future innovation, it seems like it makes sense. The third thing we can do is just extend the research and experimentation tax credit. And so the tax credit has been extended 14 times since 1981. That sounds great in theory when you except when you think of the fact that something shouldn't be extended that many times. It shouldn't be a yearly thing. It should be permanent. Businesses should know and should have the certainty that taxes will be able to be written off if they're taxes or if they're spending for innovation. So this is something that should be permanent. And fourth and finally, we should look at our immigration laws. When we look at the role that immigrants play in terms of math and science, when we look at half of new technology startups being founded by immigrants, we should say, are we doing everything we can to marshal all of these resources? And the answer is no. You look at the Immigration Act from 1965, and basically the point there was family unification, which is a worthwhile goal, but it should not be the only goal of the immigration laws. What could we do? We could do something like having an automatic green card for foreign students who graduate with a math and science degree. As soon as they graduate with that degree, as soon as they get their PhD, don't send them home. Give them the chance to stay in this country and to help out the United States. That seems to make sense to me. Also, there is something called the INVEST Act that a bipartisan group of legislators introduced in December of last year, which would basically create a new visa category giving permanent residency to those immigrant entrepreneurs that started a business and met certain thresholds, which are pretty low, like creating 2 new jobs or investing $200,000 after 2 years. The point here is if we have immigrants that are creating new companies, bringing wealth into this country, this is something that should be rewarded rather than kicking them out because they don't meet the requirements of immigration. So these, to me, seem to make common sense. They overlap with a lot of the comments this morning about what the government can do. Yes, there are funding issues, but no, they're not the biggest deal in the world. They are something that we can do, and I think because innovation is so important, these are things that we have to do. So now let me shift to something that has not come up and something that most people don't talk about when they talk about innovation, and that's copyright law. So a few years ago, I wrote a book on patent, antitrust, and copyright law, looking at the role that those laws could play in terms of innovation. And what I saw was that patent law gets a lot of attention for good reason. Antitrust law does as well, usually on the downside. Everyone says, oh, or a lot of people say antitrust law is too slow to deal with innovation, so antitrust don't do anything. But very few people talked about the relationship between copyright and innovation. And what I found is that copyright, in particular the law of secondary liability, has a significant, or could have a significantly adverse effect on innovation. So by secondary liability, I mean companies that assist others in committing copyright infringement. We have those that are directly liable, for example, by downloading a file or making a copy, and those that assist in infringement, those that are makers of technologies like the computer, the VCR, the iPod, you name it, that assist others in engaging in infringement. And my concern here is that the law is so amorphous that we're stifling innovation. And so just to give a couple of examples of how we're about to get a lot worse, think of the recently brought up congressional legislation, SOPA and PIPA, the Stop Online Piracy Act, the Protect IP Act. Those did not become law because of an outcry, but there was a significant chance that they would have become law and they could come back. And those laws are really broad because they would punish any company that, quote, enables or facilitates, close quote, infringement. Enables or facilitates is really broad. It applies to any search engine, because you could just search for a copyrighted work. It applies to a credit card company, which could allow you to buy access to a copyrighted work. It applies to advertisers or anything else. And so when you look at language that's that broad, that language is picked up in other places like treaties. So we have the ACTA, which has been negotiated behind closed doors, that deals with aiding and abetting liability. Again, aiding and abetting from the criminal law context can apply really broadly to literally anyone that has anything to do with copyright infringement. And there are other treaties coming down the pike. Chances are you haven't heard of them because, again, they're being conducted in secret. But the Trans-Pacific Partnership Act is another one that would punish the making available of copyrighted work. Making available, again, is really broad. The problem with all of this is that when you get this language that's really broad, it can be used to stifle true technological innovation, because a lot of this technological innovation is good and has all sorts of benefits, but it also could potentially be used for copyright infringement. So one of the difficulties we have here, picking up on Josh's point, is we don't know the counterfactual situation. We don't know the innovation that we would have had in a different regime. And so one of the things that I've tried to do is to figure out the innovation that we could have had. So in one of my projects now, I am interviewing CEOs of technology companies, record label VPs, to figure out the relationship between digital music, copyright, and innovation. And in particular, I want to see what happened after the Napster decision. So back in 2000, the court for the first time found a peer-to-peer service, Napster, to be illegal, or at least find an injunction was appropriate in this setting. What happened after that decision? And by talking to folks, it seems like there really was a significant effect on innovation. Some of the things that people have said is that Napster, quote, cast a pall over funding, that there was an overflowing graveyard of music companies, that it scared away investment for a decade. And so this is all useful evidence to see that the law really can have an effect on innovation. And if you're going to punish technological innovation, that could really have an effect. So when you think of all of the things that the law could do, I would say that clarity and carving out a space for technological innovation is something that we do need to do. Look at the flip side. Look at where copyright law is clear, and you see that there is a lot more innovation. So the Digital Millennium Copyright Act, passed in 1998, has been criticized for many reasons, but actually part of it was pretty good in coming up with safe harbors by which internet sites could keep up works, but then take them down if they receive a notice from a copyright holder that the works are infringing. The site is allowed to stay up. They just take down the copyrighted content. And keep that in mind when you think about current legislation like SOPA and PIPA that wouldn't just deal with that particular work, but the entire site itself. And so when you look at the types of sites, the YouTube, Facebook, other user-generated sites that have grown up in response to something like the DMCA, we see a real benefit. One other example, the cloud computing space increased and got a lot stronger according to a study by Josh Lerner at Harvard after this 2008 or 2010 Cablevision decision in the Second Circuit that upheld the operation of a DVR, digital video recorder. That allowed there to be certainty by which companies rushed into the space because the law was clear. So the upshot here is if the law is going to be unclear and we're going to have really broad terms like enable or facilitate or aiding and abetting, you're basically going to stifle technological innovation because no one's going to take that chance. The innovators don't want to take that chance. The venture capitalists don't want to take that chance. And so we're really losing innovation. In contrast, if the law is clear and we carve out safe harbors for these companies to innovate, then we all would benefit. Two final copyright points that are related. One deals with statutory damages. So in consideration with all of this, think of the fact that statutory damages say that you can be charged $150,000 for each copyrighted work that is infringed. You multiply that times the number of works that appear on some of these devices, and the figure quickly goes into the billions or even trillions of dollars, as one case pointed out. So for example, Viacom is suing YouTube for an amount that could reach $24 billion if you have 160,000 unauthorized works times $150,000. That's $24 billion. That does not make any sense whatsoever other than to stifle technological innovation because companies are so worried about the fear of statutory damages that they leave the space. So for example, mp3.com, which was an online library that allowed you to buy a music file and then listen to it from any of your devices. So it's not piracy. It's something that you already have purchased. They were sued because the record labels didn't like that and eventually was settled for $53 million because statutory damages would have been even higher, like $250 million. So at the end of the day, we ask, why do we have statutory damages when they serve no purpose other than being used as a sword of Damocles to stifle technological innovation? And finally, and relatedly, the fact that there is personal liability exerts significant chilling effects in this space. So when you can be sued, not only your company being sued, but you yourself in your personal capacity, that has a real effect. And again, I've talked to these innovators and they talk about the knock at the door at 6 a.m. in the morning with the police and the fire marshal showing up. They talk about the threats from the record labels. They talk about how they could win the case, but are they really willing to spend millions of dollars and years defending themselves in court? No, so they just go away, they leave the music space, and innovation just dries up. So at the end of the day, when you look at these fears of personal liability combined with statutory damages together with really broad and amorphous legislation and law, the end result of all of that is that innovation is being stifled. And so the moral of the story here is, even though we talk about patent law a lot for good reason, let's also not forget copyright law and the effects that overbroad, aggressive enforcement of copyright law could have on innovation. Thank you so much.
Great. Well, thank you, everybody. I just really want to echo the wonderful things that have been said that are not wonderful enough about our great hosts, the students and the faculty, the alum and the Thrower family supporting Emory. This is just a wonderful community, a wonderful space. Thank you so much for inviting us, and a great chance to see old friends and meet new ones. This is just a treat. I think that it's important sometimes to start with a vocabulary, and I won't give you my whole dictionary that I'm going to use today, so instead I'll refer to a dictionary, a literature, so that you can put this in context. Institution, as just a word, does have some definition associated with it. In fact, there's a whole field of people in economics and social science who call themselves institutionalists. In fact, there's a group, of course, who calls themselves new institutionalists. And institutionalists, these are folks who say to themselves, it's not just that money matters, it's not just that natural resources matter, it's that institutions matter too, and then by institutions they mean the set of laws, rules, and norms that are human-imposed and their enforcement characteristics. So it's not enough to say don't go above 55 rather than saying don't go too fast. Instead, you have to also ask, do you only pull over people who go above 55 who look a certain way? How do you enforce the laws, rules, and norms? What are the laws, rules, and norms? And then the central lesson of the field of new institutional social sciences is to ask not only what are the laws, rules, and norms and their enforcement characteristics, but how do we compare them? So I'd like to try to compare and contrast some. I want to also make a political point. I don't think this is fundamentally about left or right. In fact, it's interesting to note that famous local boy made good, that famous Georgia son who went to Washington to enter the national political space, that staunch right-wing conservative, you know his name, Jimmy Carter, made it the single biggest part of his domestic policy initiative at the end of his administration to strengthen the patent system by creating the court on which Chief Judge Michel served. And it was then signed into law by that radical lefty, Ronald Reagan. So this is not a left-right, Democrat-Republican debatable issue. And as the Chief Judge pointed out, in fact, both the Bush and Obama administrations have tacked in a totally different direction. So Carter and Reagan on one hand, Bush and Obama on the other hand, left and right on both. And so I also think it's worth pointing out that this is not about no government or no law. In fact, this is a discussion about law. And the only way you can have law is if you have government to enforce law. So this is a talk about how wonderful law can be and how wonderful government can be in enforcing law. And let's then ask ourselves, so what do we want out of our innovation laws? What are some of our goals, and what are some basic tactical choices or implementation choices we can make that will play out differently? Look, we could have a basket of money and we could target I spend a lot of time in Boston. Up there they say wicked smart. We could target the wicked smart people in the room. We could find you all and give you all a check. And in order for us to do that, we have got to be pretty wicked smart ourselves, right? Because I have to be able, if I'm the check writer, to know that exactly you should get the check and not you, and it should be this big or 0.1 bigger or 0.9 smaller. An immense amount of information has to be had, has to be brought to bear, and then has to be used productively to write those checks. That would be one strategy, and I'm not against writing checks in certain settings or tax credits or rewards or Nobel Prizes or other things. But it is worth noticing that giving property rights can have an alternative effect. And it's actually totally different. You see, if it turns out that any one of you happens to have a property right, and say, for example, this is a room with no windows, we don't have to pull down the shades, but maybe we turn out all the lights, and one of you has a flashlight, and you turn it on, what do everybody else in the room now know? Exactly where that person is. And we know if we're interested in that flashlight that person's holding, we can find that person, we can find that flashlight that they're holding, and who else are we going to find there? Everyone else who's interested in the same thing. You see, so it turns out that if you give property rights to a diffuse set of people out in society. Everybody, the many different people who might use that asset, the one who happens to have it in her hand, and anyone else who might be interested in it, all know how to find them and talk to them and talk together. And what a horrible world we will live in when we actually, dare I say, talk to each other, right? What a nice thing when all the many complementary users of the asset can find each other and talk to each other without the government having to figure out all of that strong form of information. The government has to figure out if it instead wants to target specific checks. You're a great venture capitalist, I give you that tax credit. You're an amazing inventor, I give you that reward for inventing. And golly gee, you're a great marketer and a manager and a laborer and a skilled laborer and an unskilled laborer. Oh, and you've got some complementary technology. The government has to find all of those people and give them the exact levels of exemptions and credits, and instead, you give a property right. And then they all have an incentive to find each other and dance with each other, do a deal with each other. Now, there is a concern, of course. Property rights could lead to no access. After all, a property right backed up by a right to exclude is all about excluding use, so that must mean we'll get no use. I work at a private university. Emory is a private university. I'm not an expert on local law, but my bet is you can kick people off if you want. We can. Except it turns out that if you go to most private universities, or let's take it out of the university context, go talk to the Donald, go to Trump Plaza. He ain't known to be the most open-hearted guy in the world when it comes to giving people his own stuff. But yet you and I, we can go have lunch in Trump Plaza. Strangers can walk on to all sorts of real property assets and get large numbers of low-value uses for free. And there's nobody checking tickets, and there are no people with shotguns standing around. Massive quantities of people get low-value uses, that market clears, and there's no fair use exemption. There's no fair use exemption. There's no experimental use exemption. In other words, the property regime manages to tailor itself in such a way that is, in fact, in the law, absolutely non-tailored. A person who has a fee simple title can exclude all trespassers if she wants. She can sit outside and she can sue everybody all day long. And as expensive and as frightening as it is for potential infringers to infringe, it's expensive and frightening for property owners to spend all of their days in court suing everybody in order to collect what? Actual damages and maybe an injunction. Please don't come back onto Emory's campus. And the damages will be 79 cents, $1, $1,000. The cost of the lawsuit will be $1 million. Property owners don't choose to do that, which is why people walk on and off campuses freely all the time, and people wander through Trump Plaza all the time. No fair use. It's just under enforcement by the property owners themselves. And then the property owners, the property regime leaves to the property owners the rational choice. Hey, don't bother to sue the low-value users. Stick an anti-adverse possession plaque and an anti-prescription plaque on your floor that says, permission's hereby granted, you can come, but it's revocable. And what does that do? That preserves the outer boundary so that when the property owner wants to sell the asset, she can sell the asset. And when she wants to enforce it against a commercial competitor, she can enforce it against a commercial competitor. Patent system has long rightly had no fair use, no experimental use. And the copyright system has a radically different approach. It's an approach that says lots of statutory fair use and lots of statutory damages and criminal liability to, quote, get the balance right. Patent system doesn't take that position. It doesn't try to get the balance right. It lets the owners try to get the balance right. A very different institutional approach. In fact, let's take it at a different level. Let's talk about enforcement mechanisms, and let's talk about courts versus agencies. Litigation is very, very, very expensive. It takes a long time, and that is a problem. But there are a lot of really, really good reasons we want it to take a long time and cost a whole lot. Because when you go to court in front of a Seventh Amendment jury, in the end, de facts is de facts. I got a lab notebook, it's got a date. You got a lab notebook, it's got a date. And a regular lay Seventh Amendment jury can look at the date, and she or he in the jury doesn't need to have a PhD in rocket science in order to tell whether my date is before your date. And when I put my witness on the stand and she talks about the lab notebook and she's sweating profusely and blinking because it turns out all the ink on the page that's about the technological information is blue, but it turns out the ink relating to the date is red, and she's trying to tell you, oh no, I specifically remember switching pens that day, and she's blinking and she's fidgeting. She's lying. Jurors know that. They can handle that. That doesn't require a PhD, and that doesn't require executive branch expertise, and it doesn't require administrative deference. It's a pure play straight down the middle of the strike zone fact question. And it's not an accident that we send fact questions like that to courts. And yes, golly gee, the federal rules of civil procedure and the federal rules of evidence do take some time because you have to marshal the facts. But maybe marshaling facts is the right thing for society to do. Because the argument in favor of agency adjudication is fast and cheap. Cyanide is fast and cheap. I don't recommend it. Fast and cheap is not, there are all other things being equal, it'd be better to go faster and less expensive. But it turns out all things are not equal. And if you go fast and cheap with reckless disregard for accuracy, which is what you do when you don't build a factual record. Remember, the entire argument in favor of administrative expertise is defer to the examiner's expertise. Don't make her go build a full trial record. That's how you save the money. But if you're saving that money by not building that factual record, it's because you're allowing the decision to be made by an examiner who will say, trust me. Trust me. I remember June 1995 in that field. I totally would have done that. I mean, because I'm awesome. I always do stuff like that. And you didn't come up with anything. But trust me, wait a minute. Why not have a record? Why not have cross-examination? Why not have lab notebooks? Totally different approach. This morning there was a reference to Dickens and Bleak House. I thought we were going to go in a different direction. Dickens wrote an amazingly fun short story that I recommend to all of you, A Poor Man's Tale of a Patent. And it's about the absolutely ridiculously administratively complicated patent system the British had at the time. And the story ends with the phrase that the inventor quotes. He says, "I was worn out, patience and pocket." And as the Chief Judge pointed out, you too, inventors of the world, will be worn out, patience and pocket, when you're done going through many years of examination, re-examination, post-grant review, inter parte review, no injunction and no stay, and by the way, maybe not even enforcement for violation of an injunction if you get it. That's what it means to be worn out, patience and pocket. So let's take a very, very, very specific example. In the patent system, down in the weeds, what should the standard be for patentability? It used to be that for an invention to be patentable, it had to be an invention. Well, wait a minute, that's kind of tautological. And that was a very subjective standard. And we changed the rule on that on purpose. We changed it to a different word, obviousness, not because we thought the word obviousness had any obvious objectivity that was more objective than the word invention, but we picked a different word because we know what lawyers do. They have case law, they have precedent, and they do word searches. So we picked a different word to jettison all of the old case law. And the new statute didn't just say obvious. The new statute set forth a legal test for how you determine obviousness, and it was focused on an objective standard rather than a subjective standard, under the theory that subjective standards become the political plaything of the decision maker, and that always ends up playing to the hand of the companies or the interest groups that have the most established and most effective public advocacy voices. That means you get a patent system that favors the large established players and not the small market entrants. That favors anti-competition, not competition. That turns the patent system into a system that, in fact, increases monopolies. And who supported that crazy bill? That bill in 1952, one of the central focal points of which was to switch from the subjective standard to the objective standard. Another strange political group. The three loudest voices, three very famous jurists and judges and academic and practitioner scholars, in New York, by the way, Jerome Frank, a strong populist in the New Deal tradition, became a judge on the Second Circuit, a commissioner at the SEC. Learned Hand, not generally viewed as a conservative, usually a centrist Democrat, and Giles Rich, who registered as a Republican during his nomination process because the administration was Republican and said, it'll kind of help us get this deal done if you could at least register. That was not some right-wing, aggressive property, wealth arrogating bunch. That was a fairly diverse group that saw an objective standard and property rights as a way to increase competition and access. In fact, in the words of Jerome Frank, that's what made patents the vital slingshot that the Davids of the world used to take on the Goliaths of the world. Now, maybe this is all fantasy. I agree we have to ask questions about empirics. We have to do natural experiments. It just turns out we've done some natural experiments in this space. Bayh-Dole is interesting, but Bayh-Dole is like the street game of three-card Monte. It takes your eye off picking your pocket. The big change around Bayh-Dole was not Bayh-Dole. The big change around Bayh-Dole was the creation of the Federal Circuit and the Supreme Court's decisions in Chakrabarty and Deere to totally toss out a set of arguments that software and living things and biotech were not eligible for patent protection. So let's talk about that natural experiment. Before 1980, US, Europe, and Japan had no patents in basic biotech. After 1980, only the US had basic patents in basic biotech. That's a natural experiment. That's a comparative institutional analysis. That's real time. That's live. And what happened? Only in the US and only after 1980 did you see a massive increase in the number of new drugs and new devices brought to market and a massive increase in the number of small and medium-sized biotech companies. We had big pharma. We still have big pharma. The rest of the world had big pharma. They still have big pharma. The shift was not big pharma. The shift was the small and medium-sized enterprises. We grew a massive population. Now, that could have shut down basic science. That could have closed universities, because universities infringe basic biotech patents all the time. But just like universities don't stand with people with shotguns to stop trespassers from wandering in, the patentees didn't sue the universities for basic academic use of the patented technologies. In the 30 years since the Chakrabarty decision creating patents in this space, there have been none, 0.0 lawsuits brought against basic academic scientists for doing basic academic work in biotech. There have been 2 or 3 lawsuits brought in that space by people who are dual-hatted, people who are basic academic scientists and also run commercial enterprises. They charge patients commercial rates to do things like breast cancer screening. And even those people didn't get sued for patent infringement. Those people had to bring a declaratory judgment action against the patentee to say, it's not that you're suing me, it's that I have a reasonable apprehension that you might sue me despite 30 years of no lawsuit. And that's now the question before pending at the moment the Supreme Court. Oh my gosh, the sky will fall if we have patents in basic biotech. 30 years, it hasn't fallen yet. So we've seen very, very good real-world examples. And by the way, what about the software example? The Deere decision in 1980 didn't really resolve the ambiguity. In fact, it was the Allopat decision in the Federal Circuit about 15 years later. And what do you see in that time frame? From the 1972 Benson decision tossing out software patents to the 1994 Allopat decision saying basically software patents in fact are allowed, what do you see? Microsoft, a single large player in the space. Absence of patents in software, monopoly. Presence of patents in software, what do you see after that? A massive growth of small and medium-sized enterprises in the software space, competing against companies like Microsoft, like that little player, what's its name again, Google? Which in fact was started with a massive portfolio of very, very strong IP rights in search technology, some trade secret, some patent. The single biggest competitive threat to Microsoft is not antitrust enforcement. Antitrust enforcement bothers Microsoft dearly, but it's not like the Justice Department is going to sell its own software. The single biggest competitive threat to Microsoft is Google, a company built around strong IP. IP is part of the solution, it's not part of the problem. So I guess in the end, what I just hope we can do is think about these different institutional choices. Yes, we should have law. What's an advantage of law over just norms or informal ordering? An advantage of law over informal ordering is that informal ordering has been shown to work extremely well. It is awesome. It's right up there with sliced bread and round wheels. It is more effective than law. It is cheaper than law. But here's the catch. It requires homogeneity among the participants in the society. But if you want a diverse society and you want stranger interactions, then you need law to facilitate those interactions. So that's one institutional choice. No law or law. I vote law. This is not about no government. This is not about no law. This is about law of particular types. We could give grants and we could know everything about everybody and grant them or tax credit them or exempt them exactly the right way, or we could have property rights, which requires the giver to know very, very little, very, very little, and allows people out there to coordinate with each other over those assets. And we could have agencies make all of the decisions and then be subject to political influence. Surely no one's going to make the argument that our government isn't subject to political influence. Not today. Or we could have courts do it and basically make the courts rely on facts. Lastly, let me just point out, one of the real benefits of litigating is self-discipline. One of the amazing things about any argument is if you make the argument alone, you can easily get into hyperbole. You can overstate your case. One of the nice things about litigating patent validity is that both the infringer and the patentee have to talk directly to each other, in front of the judge. And so while a person challenging a patent in an agency might have an incentive to say, oh my gosh, this patent claim is so broad it covers all the prior art. In court, where they also face an infringement argument, they don't want to argue the patent's that broad. In case they lose on validity, it will capture them on infringement. What's nice about litigating is both sides have that self-disciplining effect. They don't overstate their claims. Thank you.
Those were all wonderful presentations. We have just a few minutes for questions. If you have any questions from the audience. You can come up to the microphone.
Keith, you just talked about Diamond versus Chakrabarty and how that kind of sparked the biotech industry in terms of expanding what was patentable. Do you see something similar happening in the future in another area that would expand the similar scope and spark a similar sort of innovation?
The word expand is a complicated word because it is a relative word. And I think it's fair to read Chakrabarty and Deere and Allapat and State Street and cases like that as not expanding. I think it's fair to read them as basically saying, we have a very, very tough time finding the legal argument that there is, in fact, a meaningful limit on statutory subject matter. And indeed, I think those opinions would basically say the prior opinions cast a shadow of uncertainty about whether there were limits. And these are opinions that said, roughly speaking, when we read 101 and we read 101 against the history, context always matters, not making a detailed legislative history argument. I'm making a rough context argument, which is that 101 was written against the context of a whole lot of cases that seemed to create exceptions, and 101 was written to rule in what those cases arguably or did rule out. And Chakrabarty, Deere, Allapat, State Street, cases like that were written to basically say what I just said, which is 101 really doesn't impose meaningful restrictions. So on the question of where we're going to go next, the imagination of the litigants is the limit. So, I mean, it kind of strikes me that we have to keep revisiting the issue, given that 101 was written to say everything's in, and that we then keep having cases saying, no, no, we really meant everything's in. Where's the next one? I think it's just going to continue to be anything related to life, because that raises a set of political issues, and anything related to large concentrated industries where they can lobby, and that's software at the moment.
My question is for Professor Vertinsky. I was wondering where students fit into your model, or this proposed model of universities as managers of post-discovery development, and whether you see a tension between research and teaching in this sort of drive to foster innovation.
A lot of answers to that, so, but don't worry, I'm not going to give you them all. But actually, so let me give you one example where I think students play a critical role in a variety of different ways. One simple example is in the context of access to essential medicines. So there's now a national organization with chapters in pretty much every major research university and in other places as well. There are student groups who have a voice in how universities handle their licensing practices. It's not a controlling voice, but it's an influential voice. And in Emory, for example, the student branch of that student organization, which is called EGAP, had a role in changing and helping to change Emory's guidelines for licensing to include access principles. The notion being that making discoveries that could lead to life-saving drugs accessible for developing countries, for example, is a part of the guidelines they need to use and think about when they develop drugs. So in talking about multiple stakeholders and the importance of that in making a university a good manager, I look at students as playing a really important disciplining role on how resources are used for future benefit, because they are going to be the ones who are affected most by the decisions that are made about how those resources get played out. That's just one example. I have a number of other examples, but this notion of students as stakeholders that are involved in managing the process, and also as stakeholders that then go out and use the technologies themselves, is critical.
Could I do a quick follow-up on that? So great ideas, but in the spirit of injecting controversy, let me offer a countervailing concern, which is the way I understand the history, the motivation for Bayh-Dole was, roughly speaking, two things. Some uncertainty about who would own, and an immense amount of anxiety about how you would get a university to even decide who would own, which is to say, universities, because of exactly the approach that you're advocating, tend to take a massive amount of input from a massive number of stakeholders. And if you've ever watched Monty Python's Life of Brian, you know that that leads to adjourning the committee with an agenda to one day reconvene a meeting, to someday set an agenda, to maybe hear from an argument about perhaps considering another voice, to then calendar a session where we have quorum rules discussion, to you know where we're. Universities don't make decisions on a dime, and nobody invests in assets that are held up in that process. And Bayh-Dole was written to, in fact, directly counteract what you're advocating. And I think it's a good idea, and I think it's a great paper, and I encourage discussion of it. I just really think we should not do it. And I think we should not do it because we've run that experiment. And that's why we passed Bayh-Dole. In fact, let me give you, I love teaching corporate law as well. This is a student example I give my students all the time. The morning Martha Stewart got sentenced for insider trading, she made tens of millions of dollars. Why? Well, in part, the market had estimated that the number of years she'd get in jail was going to be slightly greater than the number of years she did get, and they were worried that that would take her out of the company and that she was a good CEO, so that lowered the company's stock too much. So when she got a lighter sentence, the company stock went up a little bit because they were now expecting a return of their CEO sooner. That's part of the explanation. When you look at the event studies, and there have been a lot of them done on that case, that only covers a small amount of the change. The biggest amount of the change was certainty. As soon as the judge ruled, the market knew how long she was going to be out of the CEO suite, and that means they knew when she was going to come back. And that was worth tens of millions of dollars, actually about $100 and some odd million to the market. She happened to have a lot of Martha Stewart Living Omnimedia stock, which is why her net asset value went up tens of millions of dollars by going to jail. Certainty matters. People invest around certainty, and the Bayh-Dole problem, I think, was designed to create that certainty.
Okay, we're really out of time, and I know, Josh, you really want to just respond quick.
Just a couple of things to make it more provocative. So much, and it goes back to a point both Michael was making and I was trying to make, which is that Bayh-Dole, but in large part, was based on the idea that not universities were bad stewards, but the government agencies were bad stewards of the ownership. And, you know, universities now have the 9-point licensing strategies, lots of different ways to choose to exercise the right. So it may be less about, you know, whether or not you have property rights at all, but who's going to own them, and whether or not the ownership choices lead to under-enforcement in the way that you're suggesting, Scott, or lead to chilling effects in the way that Michael is suggesting. And those are questions which have not been adequately studied, no matter how many studies. The last thing I'll say is I'll disagree with Scott on 101. I'll refer you to the Hastings article I just published, so leave it at that.
Okay, please join me in thanking our panelists for...
That was great. Really fun.